Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Noor Basyirah Binti Baharuddin and my metric number is 195199. So this is oral presentation in pair for subject commercial law MGM 3351. And the topic that I and my partner choose is the case between 30 Maple Sundram Berhad versus SITI SAFIYYAH. So without any ado, let's get started.
Assalamualaikum warahmatullahi wabarakatuh. My name is Noor Farihah Binti Zaidi and my metric number is 195123. So today I'm going to be presenting on this case about the plaintiff 30 Maple Sundram Berhad and the defendant SITI SAFIYYAH binti Muhammad Firdaus Chew. So a little bit facts of the case. The case is all about the plaintiff and the defendants, which the defendant has infringed the trademark of plaintiff clothing, footwear and headgear. The defendant has exploited the trademark by selling and distributing the product as an individual, while the plaintiff is a private limited incorporated under the law of Malaysia, involved in the business of manufacturing, supplying and promoting the sales of clothing. The plaintiff is a registered proprietor of the following trademark in the class 25 for clothing, footwear and headgears. The plaintiff found that the defendant was actively using the Instagram to sell the headscarves using the plaintiff trademark. The legislation is referred to Trademark Act 1976, Section 35, Clause 1, Section 36, Section 38, Clause 1, Clause A, Clause B, Clause C, and Section 40. The plaintiff has made a trap purchase to confirm that the defendant has actively selling and promoting the plaintiff trademark.
So the case is about infringing the plaintiff's trademark. First of all, the defendant has infringed the plaintiff's trademark. So it has happened since 2014. The defendants manufactured, supplied, distributed and sold clothing, particularly headscarves, bearing the plaintiff's trademark in Malaysia. In May 2017, the plaintiffs discovered that the defendant was actively advertising, distributing, offering for sale, promoting, selling headscarves and snow cap that bearing plaintiff's trademark, which were not the plaintiff's product, which in other words, it is the infringing product, through her Instagram account. So the plaintiff decided to direct her PW2, which is her second witnesses, for the company who made a trade purchase of the infringing product from the defendant. And after the purchasing has been made, the founder of Dark brand, which is Vivi Yusof, made a video on her YouTube channel regarding this topic, which is infringing product, by using all the infringing product that they get from the trade purchase. So upon confirming that this purchased product were not the plaintiff's product, so the plaintiff instructed its solicitor to send a cease and desist letter dated on 26 December 2017 to the defendant via email and WhatsApp Messenger. So it is demanding that the defendant cease infringing the plaintiff's trademark. So the defendants initially ignored the plaintiff's previous letter, but on 4th January 2018, she replied that she had taken down all the postings that relating to the infringing products from the infringing page, which is her Instagram page that she made. So, however, the defendant failed to reveal the source of the infringing products and deliver them up, as well as pay compensation to the plaintiffs. Nonetheless, in May 2018, the plaintiffs again discovered that the defendant had again recommenced to promote and sell the infringing product on the infringing page through her Insta stories as well as Facebook account. As the consequences to the defendant's action, the plaintiffs has started this suit again. The defendant has, however, submitted that it has no case to answer, and for the consequences is found in the Court of Appeal. So, according to the trial law, that once a defendant in civil proceedings makes a submission of non-case to answer and elects not to call the evidence, then all the evidence led by the plaintiffs must be assumed to be correct.
First and foremost, the perpetual injunction by the judge's decision, the defendant is restrained from doing infringing the plaintiff trademarks. This is include distributing, selling, importing, exporting, disposing of, parting with possession of the products bearing the plaintiff trademarks. Also, the defendant is prohibited to advertise the products such as on Instagram, Facebook, or any other way which is restrained. Fourth, the defendant using the plaintiff trademarks that is likely to deceive or cause confusion in the course of trade.
Secondly, it is the plaintiff's option which the plaintiffs ordered the defendant to destruction of all or any infringing products in the possession, power, custody, and care of the defendant at the defendant's cost, and the verification on oath that the defendant is not in possession, power, custody, or control of any infringing product. Third, the defendant shall pay the costs and expenses for the preparation and publication of notices in the local Malay, Chinese, and English press to notify the trade and public that goods bearing the plaintiff's trademark sold or offered for sale by the defendant are not authorized by the plaintiffs, and to express regret of the defendant's activities within 14 days from the date of this order.
Fourth, for the exemplary damages, defendant is charged with the rate of 5% per annum from the date of filing the summons until the date of full settlement. Last but not least, after the defendant submitted that there is no case to answer, it is incumbent upon the plaintiff to prove that the defendant is neither the registered proprietor nor the registered users of the trademark. The defendant also used a mark identical with so nearly resembling the plaintiff registered trademark as it likely to deceive or cause confusion. The defendant was using the offending mark in the course of trade, and also the defendant was using the offending mark in relation to goods or service within the scope of registration. Last but not least, the defendant used the offending mark in such manner as to render the use likely to be taken either as being used as a trademark or importing a reference to registered proprietor or the registered user or their good or services.
And as for the conclusion, the plaintiff met the elements and requirements to sustain and succeed in its cause of action of trademark infringement against the defendant. Meanwhile, the defendant has neither laid any evidence nor disagreement in defense to demonstrate that her acts did not amount to infringement as provided. In other words, this case is won by the plaintiffs.
That's all from us. Thank you.
Thank you. Bye.